Is there a time that he's coming?
He might be early. I can let him know.
Just let me.
Because usually he'd show up like even 7:30 at the end of the parking lot normally.
Okay.
Tell him.
Tell him I'm in.
You ready with
Okay.
Mr. Quinn's case?
We are.
Okay. This is Matthew Quinn, case number 5208. Record to reflect Mr. Quinn is present here in court today. Thank you, counsel, with your consent.
Your code on behalf of the people.
Thank you, Richard Trish, on behalf of Mr. Quinn.
Thank you. This is the final status conference in this case. We have trial set for February 12th. Mr. Trish, are we going to be proceeding to trial?
I don't believe so, Your Honor. We have a resolution. Mr. Quinn has, the court recalls in the last hearing, he was getting together the restitution money. He's provided a check to my office. We're going to get that issued out to the prosecutor so that she can take care of it. The anticipation is that should all be done before the end of the week. And I believe the prosecutor then will not be the case.
That is correct. It's a $62,000 check, so we just want to make sure everything goes through and clears, and then we'll prepare the nollie.
Okay. You need to be to address the record.
There is just one thing. Mr. Quinn did indicate to me that he does, he's hoping to leave the state this weekend. I'd asked to address his bond. He's provided the cashier's check to me. I'd hate to have paperwork not get completed in time and cause him not to be able to leave.
So,
I don't think he has any criminal history, given that he's provided the check. I don't have any objection.
okay, Mr. Trish, if you just prepare a stipulation in order, then if it's not valid by then, we'll have that as a backup.
Certainly will. Thank you.
Okay, thank you.
Thank you, Your Honor.
Awesome. Thank you. Appreciate it. Really quick, is your client here?
He is.
Okay.
I
Maybe take
just wanted
these
to-
early if you want.
That would be good. If I could just talk with Ms. Pope for one moment.
Sure.
Let's see him. Trle here. Sorry for him.
Ready?
But he's not a drug user. I'm curious. Basically, they don't want the drugs to use. I mean, we got all the information.
Restitution is based on the request. I don't have a request.
The court called People versus Townson. This is case number 235-215.
Sierra Coke on behalf of the people.
Bring it over to Mr. Townson. He just identified that.
I did get a written request, Mr. Townsend, to move out the sentencing today so that we could have some more time to gather some letters, support letters, as well as go through the PSI with your attorney.
No, Judge. So Mr. Townson indicated, I received the PS on the 9th. We mailed it out to Mr. Townson. It looks like with the holiday, with Martin Luther King Day, Junior Day coming in, Mr. Townson just got it yesterday. That's what he tells me. So I haven't had a chance to review that with him. He does have some corrections. He's gone over it. So either the
Not
court.
thoroughly, yeah.
So that's what we were doing out in the conference room. So it's up to the court. If the court wants to adjourn it, I don't have any objections to that. But if the court wants to give us time, I'll spend time with him this afternoon and come back.
So, we'll take any questions.
This case has been going on for over a year. Mr. Townsend has three.
Mr. Townsend,
So just
go ahead, Ms. Pope.
I made the offer in June of this year. We were on the cusp of going to trial. Mr. Townsend has 3 prior felonies, 7 prior misdemeanors, and a juvenile record. He's pretty familiar with the criminal justice system. I don't mind adjourning it for a few minutes today, so he can review it, but I'd like to do the sentencing today if possible, so we can move forward.
All right, well, Mr. Townsend's by statute or rules entitled to receive the PSI no less than 2 days prior to the hearing. Have no reason to doubt Mr. Gerbert's reputations here today, so the court will grant until the court's next motion date of 14 days. Set it for reset for sentencing at that time, because in my view, Mr. Townsend hasn't had the amount of time.
If I may, I want to get those letters to you. Another thing.
All right, understood. So we'll reset it. Mr. Townsend, for that next hearing, just make sure that. Okay.
Yes, I appreciate it. Thank you.
I think we're ready, Mr. Trle.
I am good.
This is Sean Trle. This is case number 235197.
Here, on behalf of the people.
And you're with the
Record should reflect Mr. Trle present here in court today. This is the date and time set for sentencing, just so counsel is aware. Mr. Gerber had received letters from Mr. Trle himself. I reviewed those. I also received some letters that were submitted on his behalf. Did a chance to review those as well. And Ms. Anderson's pretrial supervision report. So received and reviewed all of those documents in addition. After that, Mr. Trle, have you had a chance to go through the PSI and talk to Mr. Gerber about that? Yeah. Are there any additions, deletions, or corrections, Mr. Gerber?
No, Judge.
Are there any others or any guidelines?
No, Judge.
Ms. Coach, do people have any additions, deletions, or corrections?
No, Your Honor. No, Your Honor.
Anything on the guidelines?
I understand that Mr. Trombley has health issues, but this is his 3rd felony, this being a high severity felony with 4 misdemeanors. He just got out of prison, I think 3 years ago, and now he's looking at possession of methamphetamine. I think that the court should order either 30 or 60 days in jail. I think punishment needs to be a part of, cases with when they're high severity felonies, when they have this type of criminal history. So I think it's appropriate to do some jail. Thank you.
Thank you, Mr. Gerber.
Because the last time Mr. Trombley was in any trouble was in 2015. He did his prison sentence, was released in 2021, and hasn't had any criminal exposure since he's been out of prison. This is his first exposure to at least any sort of drug-related offenses. Mr. Trombley in his own statement indicates that, he knew there was meth in the vehicle, it was somebody else's vehicle that was driving, and was going to go pick somebody else up. And Ms. Anderson's report also indicates that he hasn't tested for any substances while on bond, but did have those little mishaps when he didn't have his phone and was not returning the call. And we had a hearing here based on that show cause, and the court, we'd asked the court to order Mr. Trombley to submit to a testing that day, which he did, and that was negative as well. So I don't believe that Mr. Trombley is going to violate the terms of the 74-level status of the court, puts him in that. I would ask the court to follow that recommendation, not incarcerate him, and let him continue on the path he's currently at. He indicates he's living with his friends. He has a good support system in Roscommon where he's residing, and indicates that he would take advantage of the 74-level status and have his office record for the years of time and not violate any terms of probation. That's all I have, Judge.
Okay. Mr. Trombley, was there anything you wanted to say? I did read through the report. Like I said, contains a lot of information about you and your circumstances and what happened in this case. I also, as I said, reviewed the written statements that were submitted. And looking at the circumstances as a whole, I think the recommendation is appropriate. The court's going to follow that, with the exception that I am going to impose some jail time, but hold that in abeyance. And you've done good generally while you've been on bond. And if you do well on probation, you won't ever have to serve that jail time. But I think having that kind of held over your head, hopefully, number one, will provide some additional motivation for you to comply with the probation. But it's also going to provide a measure of consequence to you if you don't. And at that point, it'll be ideal. I'm giving you the opportunity to avoid jail because of the circumstances here. But again, if you violate probation, then you'll have to serve the jail. Totally understand. And that'll all be in your court completely. So the court will follow the recommendation and sentence you to probation of 12 months pursuant to 7411. The court will adopt as the terms of your probation all the terms and conditions listed in the report. So the court is going to order that you serve 90 days in the Crawford County Jail, credit for 3 days served. That time to be held in advance to be served at the discretion of the court. The crime victim's assessment of $130, supervision fee while you're on probation of $30 per month, court costs of $325. Because it's probation is pursuant to 7411, there's no outrights at this time. Just make sure, Mr. Trle, that you communicate with Mr. Haven. Mr. Haven, you're going to be the supervising agent.
Yes.
Make sure you communicate with Mr. Haven so that you fully understand all the conditions of information. Okay. Hope anything further on this file today.
No.
Sure.
No, Judge, and I believe Mr. Trle does not need his appellate paperwork because it's not a final sentence.
Correct.
Thanks.
Good luck to you going forward.
Thank you, sir. Yeah, plug. Just wait for me. I'll get up in a minute.
People versus Everett Bradford, case number 235202.
Jericho can be off the people.
Your Honor, Renee Dillon on behalf of Everett Bradford.
Set for a status conference today. Bradford not here for the last hearing. Oh, tell me where you're at.
Your Honor, we have made an offer. We have made an offer. I do not know the dissensus wants to go to trial or accept the offer.
I have reviewed the court's ruling with my client as it relates to the last hearing because of the switch of the time and the day. I believe just by a couple of days, Mr. Bradford appeared before the court on the original scheduled date and didn't realize the new scheduled date. I discussed with him his need to stay current with his client portal and he has done that since that time to verify the court dates and communication with my office. So it was just simply a mishap as far as the rescheduling of the dates from, I believe, a Friday to a Monday. With that being said, I have reviewed the plea offer with Mr. Bradford as well as the court's ruling. And I have a proposed order following that, the ruling of the court to present to the court today. He is going to reject the plea offer and ask the court to set this matter for trial. I also have a signed stipulation in order to withdraw his counsel. He is asking for court-appointed counsel at this point.
Okay. Is the order following hearing this vote stipulate as the form on that?
Yes, and even though the court ruled we didn't have to turn over medical records, we did turn over the ones that we were able to obtain. So I provided those despite the court's ruling.
Okay. So, Mr. Bradford, do you have any objection to relieving Ms. Bailey Quick as your attorney?
No objection.
Okay, so Ms. Bailey Quick, will those orders, and Bradford, you're requesting for appointed counsel, is that correct? So, Mr. Townson, since you're here, and refer Mr. Bradford to your office. Mr. Bradford, before you leave the courthouse today, communicate with Mr. Thompson He's the one that will be making the decision as to whether you qualify for a court-appointed attorney or not. And then, before I docket this for trial, this vote, unless you have an objection, I'd like Mr. Bradford to at least have a meeting with his court-appointed counsel who qualifies for some trial list.
If we're that close to trial, do you mind if I ask if there be any co-defendants or complaining witnesses that would create a conflict? Ms. Coke?
No,
I don't believe we have a trial date set in this yet.
Oh, okay, I misunderstood. All right, thank you.
no, Your Honor, but I would ask that that be the last adjournment since this case has been pending for 9 or 10 months at this point. Counsel.
So the court will set this for a status conference at the next available date. I signed the order following the last hearing regarding the motion to compel, as well as the motion to withdraw. Ms. Coke, anything further on this file today?
Just for my records, is Miss Bailey Quick would release his counsel and then he'll be in pro per until he gets a signed one?
Correct.
Okay,
That's the order to withdraw the sign. So.
thank you.
Okay, Mr. Bradford, do you have any questions?
No, I do have a lot of doctor's appointments coming up. I'm trying to keep everybody updated. I have back surgery coming soon. So I'm just trying to, I got an appointment with the doctor in Traverse City on the 6th.
Okay.
Talk about the battle strategy about what we're going to do. I got this severely herniated disc and it's fracturing. So like not like trying to mean anything, but I'm in pain.
And I understand that. I also have an obligation to resolve your case. It's been found over since July, so don't plan on me adjourning stuff.
No, I get that. Happening to me right now. It's
You make all the appointments you want, but your court case is going to keep moving as well. Thank you. Today.
I just want to let you know that too down.
For a few minutes ahead of schedule, we'll take a short recess. We'll come back on the record in about 5 minutes. Yeah, please. People versus Paul Kuhn, case number 235256.
Here, Coke on behalf of the people.
Sorry?
Stan?
Yes.
Chairman, how do we want to proceed today? I know we did have a set for a plea hearing, but then I see that motion filed.
You can't hear him? Let me grab you.
Sorry, I'm legally deaf.
See the battery.
I don't know, because I was not here last week, so.
I'll just watch it. I just turn it on. There you go.
Can you hear me
Can you
now?
say something? I can't hear nothing.
Hold on. We'll just swap the battery from the remote.
First, I don't know if it's always or triple case. Stay.
Oh, I think it's turned off.
You able to hear anything now?
I can hear a little something now.
Man, turn the
It's
volume.
turned off. So what's this other button?
Superman, yeah.
Can you
Out
hear
there, I
us
can't
now?
Do anything from behind the
No,
screen
it went
here.
dead.
Well, it's on. I can hear this.
Maybe it's the other ear. I know I got one ear. Whoa, I can hear on that one.
Can you hear us then?
Why is it static?
Able to hear me okay?
I can see your voice moving, but I can't, or your lips moving, but I can't hear nothing. It's just static. Listen.
Fine now. The volume
It's
was
just
down.
static.
Hear us now?
No, there's no, I don't, maybe the frequency's wrong.
You can try those. I don't know if those are gonna work.
Sorry, guys.
Not your fault.
I just didn't know if you needed them ahead of time.
Right.
See if it'll just work. We can just take that.
No, it's not coming on. It's not coming on. District court. It's the one in district
Let's
court.
take a break and then see if we can get this hammered out, and then we'll come back on the record.
I'm gonna see if there's one in district.
All
court.
right, please.
If you raise your voice, I can hear you.
He's the one who has to talk.
Oh,
See if the court from next door.
I know yours works. We're gonna use that last time. Stay here or what?
Yep.
Just stand, okay.
You can have a seat.
Sarah?
Yeah.
Do we not
Yeah,
have any
go ahead.
motion dates from here till April?
I'm not sure.
See what I mean?
Well, there's two different channels. So you've got an A channel and a B channel. But I don't know, sir, because I don't wear these. So there's a volume on each one. So it depends on which channel you're on, which one's gonna work for you.
How do we know what channels he's on?
Well, it's you, not this that works, because some people have hearing aids, so they're paid for if you have hearing aids or don't have hearing aids.
Oh, I thought he just talks through the mic and.
Nope, there's nothing with the microphone. There's nothing that amplifies the voice. That's the amplifier.
Did you file an appeal?
Thank you.
Oh,
Okay.
Should be on.
Oh, I can hear you.
Okay.
Okay, so next time you come to court, you need to make sure you tell us so everything, we have stuff ready ahead of time. So
That's
let your
nice.
attorney know to tell us.
Cool. Yeah, this is perfect.
you can hear now?
Oh, yeah. Much nicer.
No.
Nothing.
Right.
I need one of these.
Just not happy the way it should have let me testify.
Sure.
I got thousands of pictures of my dogs running outside. Pictures of the kids playing in the house.
Maybe the wife will stop yelling at me so much, turn down the TV.
Because I'm not guilty. And I know I'm not, so. I just hope all I can walk with is just.
I thought the way that other one worked was he talks to the mic and it goes right to the earpiece, but
I don't know who to talk to. So.
Depends on my job.
I have no idea why he's so.
All right, please.
Thank you. All right, Mr. Kuhn, can you hear me okay now? Can you hear me?
yeah, much nicer.
Okay, good. Okay, so we're back on the record. Mr. Gurmurthy, can you tell me where we're at with this case, please?
Yes, Judge, we filed a motion is set to be heard, and Mr. Coons indicated he has a friend of his who's a radar expert that we intend to call also at the motion hearing. I don't have any credentials yet from that expert, and Mr. Coons is going to provide that to me and give me the expert
Today.
to email me all of those, so I'll share that with Ms. Coke. So that's where we're at. We'd asked the court at the prior hearing to give us some time to file the motion.
I was going to witness those behind me that day.
And we did file the motion.
Oh, sorry.
All right.
We'd ask this, get this case set for trial. I understand they filed a motion. We filed a response. I'm not sure why they set it to be heard in April. It's kind of strange, but either way, everything's set. I don't anticipate a resolution. We'd ask to get this on the trial docket.
I don't want to wait until April to get it on the list, so I will schedule the trial with the hearing in April in mind. Ms. Coke, how many days of trial do you think we will need?
One, Your Honor.
One judge. Judge, I know that Ms. Cope was not here with Mark, but she had a trial in Mile, I believe. Obviously, but not, she was a special prosecutor in another matter, which I didn't think it was like the jab.
I'll probably set it for May, if your motion hearing is in April.
Yeah, that's totally fine.
Okay.
And I would like to request the bill of particulars.
I'm sorry, what's that?
No, you said it right, but I'll ask you. Mr. Coonwood is requesting a bill of particulars.
Okay, have you submitted that request to the prosecutor under the court rule?
I have everything that I need. I asked Mr. Coon multiple times exactly what it is that he is asking for that we don't have. Don't know the answer to that.
Well, I'm gonna leave that up to the lawyers. If you haven't been provided with something, then you can file a motion.
I will. Okay.
All right. And then the court will set this for a final status conference also prior to the trial date.
If you'd like to use that April motion date, Judge, I'm fine with the final status conference right after the hearing that day.
I think that's probably what we'll end up doing.
Okay.
Ms. Koch, any other scheduling matters we can address today?
No scheduling matters. The bill of particulars is basically what's stated in the complaint. It states exactly what we intend to prove and the nature of the offense. I'm not sure what he's asking for in addition to that.
Okay, well, the court rule says what it says.
Correct.
If the prosecutors complied, then they've complied. If they haven't, then Mr. Murphy, again, file a motion and pick that up, of course.
Yes.
Okay. Mr. Murphy, any other dates that you can address for your side?
No, Judge.
All right. Thank you, Mr. Kuhn. That's all for today.
Thank you. And back to you, Jeff, again. Yeah.
Oh,
Oh,
please.
no, oh, sorry, I keep forgetting. That's okay. All right, thank y'all.
Thank you.
Do you want to see us over next door?
They need to go next door.
People versus Schultz, case number 235194.
Here, Coke on behalf of the people.
Thank you, Reverend Mertz, on behalf of Ms. Schultz, Ms. Schultz is here at the following judge.
Thank you. This is the date and time set for a sentencing matter. Ms. Schultz, have you had a chance to go through the pre-sentence report and talk to Mr. Griffith about that?
Okay, hold on.
They don't work, they don't work.
They don't work. Okay.
No. I just do this and then I can hear you.
Okay. We had the trial. You didn't say anything about having trouble hearing at the trial.
Yeah.
Yeah.
I had a hard time hearing you guys.
You never said anything. Why didn't you say anything then?
I don't know.
Okay. All right. Did you have a chance to go through the pre-sentence report with Mr. Germerthy and talk to him about that? Yes or no?
I said yes.
I couldn't hear you.
Oh,
Mr. Germerthy, are there any additions, deletions, or corrections?
No, Judge.
Are there any challenges to the scoring?
No.
Ms. Koch, do the people have any additions, deletions, or corrections?
Your Honor, we would ask to reserve restitution. We have put in a request from the animal hospital. They were gathering the information, but we have not gotten it yet.
Okay, I'll reserve that. Any other additions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
Anything on behalf of the people for allocution?
This court sat through the jury trial and heard all the facts, so I'm not really going to add much, although there are way more facts contained in the jury trial than there were in the PSI. We were all privy to that. I have struggled with whether or not I think jail is appropriate for Ms. Schultz. Given that she has done this before, these are pretty egregious circumstances. I do think some jail is appropriate. I mean, I'm not saying we need to send her to jail for a year to prison or anything crazy, but I do think based on the facts here and the fact she has done this and recently, within the last few years, I think jail is appropriate. Thank you.
Thank you. Mr. Germerthy?
Judge, Ms. Schultz is 67 years of age, no prior felonies, just 2 prior misdemeanors. Ms. Schultz is on social security income. Ms. Schultz clearly believes that she's not guilty of the offenses that she that was charged, and while she does respect what the jury found her, she still believes that she was not guilty. That's why we went to a trial in this matter. And the court sat for 2 days of trial. I think the jury deliberated for a lengthy period of time, evaluating all the evidence. They didn't believe Ms. Schultz's position, but Ms. Schultz intends to, by right, at least file the appeal. It was a trial by jury. She believes that, again, I don't know what errors she plans to raise in that, but she believes that she was not guilty of those charges and maintains her innocence of those charges as well. Ms. Schultz, I don't believe deserves any jail time, given her age, given the lack of criminal history. This is not some individual that was dealing with drugs and dogfighting. It was something so egregious that she was jailed over this. And I would again apprise the court that at one point the plea offer was a delay of sentence, which would have not put her in jail, but the idea was for her to not own dogs. And I think that is accomplished by way of the pre-sentence recommendation in the orders. I usually don't bring up what the plea offers are in cases because those are usually out of court statements, but I think it's important here because at one point Ms. Koch also believed that jail was not necessary for Ms. Schultz, but prohibiting her from owning dogs was what the goal was. I think the sentence, by way of sentencing, the court can accomplish that. And then I'm surprised that Ms. Coke today indicates that some jail should be imposed on Ms. Schultz, and I just don't think that's necessary. I think the recommendation here is well within reason. Guidelines is 0 to 11 months. The presumption is no jail. Certainly the court has the ability to overcome those issues, but I don't think that, given the family dynamics, her husband's here, they've been here in all court proceedings. They've been married, I don't know, 49 years or something. And they've been together forever. I just don't think that any incarceration resolves anything or sends any particular message to Ms. Schultz. But Ms. Schultz has the appeal process and can go through those issues and deal with those issues through the legal system. But I would think that the recommendation is over the reason. I ask you to adopt, Judge.
Great, thank you. Ms. Schultz, anything that you wanted to say today?
I don't even know how to say it. All of it's not true. Not a single word of it. When Inga Walter I got bit by a dog. So I called them and told them, the police. And she came out to meet the dog and I gave her the paperwork. And she actually, the first thing she said when she went through the paperwork, "Oh my God, you get $1,500 a puppy?" I'm like, "Yeah, but I got the pedigree in it." That is so unfair. The next thing you know, they're beating on my door, kicking my door in, and telling me that I threatened to put my animals down one at a time. That's not true. I never told her that. Never. And all I maintained is, it's a lie. You want to get the truth? You put Inga Waldrop there, and you put Carrie over there, and you ask them what happened. Carrie lost her job because of Inga. Because she wouldn't lie on the stand against me. Honest to God, on my children's lives, both of them aren't being truthful. And there's nothing I can do. I'm a nobody. All I did was breed dogs, 1 or 2 litters a year. And my dogs were health tested. And when I had my 4 shepherds and 2 little guys. The 2 little guys would take turns going in to get groomed. Big guys, we would work on their nails, and summertime we gave a couple baths. Male dogs are known for being lighter in weight before they're 2 years old. I went to school for years to learn how to be a vet tech. I worked as a vet tech for 16 years. 16 years. I didn't just turn 65 and decide, this is the day I'm going to start destroying animals and hurting them. What about the other 50 years of my life here when I did nothing but take care of them? What is that? That's nothing. Nobody believes me. Nobody believes me. But that's the truth. I don't believe in lying because there's no point in it. The truth always comes out someday, don't it? I don't think I deserve jail. But I do think the 2 of them together need to come up and own up to the fact what they did to me. When she took my dogs this last time, Carrie, there's nothing wrong with them. Nobody has any sores. Nobody has anything wrong with them. They got a vitamin every single day. They were taking oil in their food every single day. It had to do with keeping their skin healthy. The only dog that went to the vet that needed the vet was Ziva because something was going on with her ears. And I took her in. I did what the vet said, but it didn't stop. It was still happening. Then they shut me in the water. They didn't want to see her anymore. So then they came and took her. So there's nothing I could do. I don't hurt my dogs. Those little guys sleep in bed with me. When I get up, I put them in their crates, and then I feed everybody, and they go out. Granted, I don't set them out together, but sometimes I do during the day when there's just me there. I don't hurt my dogs. I have never hurt a dog ever in my life. I take care of them. I put them back together. I've done it to several other animals that couldn't go to the vet when they didn't have money. I just took care of them. I don't hurt dogs. The only 2 things in my life that make me happy are my grandkids and my dogs. She took my medical alert dog and killed her. Put her down because she said she was mean. Misty was not mean. He even met Misty. She wasn't mean. She was not a bad dog. She would wake me up when that was my problem. My sugar goes too low in the early morning hours. And she'll push me out of bed till I wake up so I can take care of it. Last Thursday, my sugar was 31 when I got up. 31 is awful low. I need a dog to help me with that. It's not going away. I'm not guilty of any of this. None. It was all made up in Inga's mind. And now it can push it. Karen she wasn't in my house the whole 8 hours, the whole time she was there. She cooked her dinner, her birthday dinner, and went outside. She went to the doctor and spent 3 days sleeping in that. Never came out, never asked for water, never used the bathroom. 3 days. I asked her, what kind of drugs are you taking? And she says, well, the doctor will give it to me because I tell him I got this wrong or that wrong. So I figured doctor shopper, when she goes on, she's not coming back. But I caught her stealing my dishes. She would take dishes out into the camper and not bring them back in. And then she would make more food, take more dishes out. I was down to 4 forks. I had to buy new stuff. She took my plates. He told me. She didn't, I kind of figured it, and I did. I went to her and I said, you have to bring this silverware stuff back in, or pretty soon we won't have any for you to take out. What, 2 days later, I'm beating my dog with a stick? Can you see how absurd this is? I cannot fathom how this can happen. I've never heard a dog, ever heard a dog. I did rescue work and placed rescue dogs. My own money paid for their spaying and neuter. There's nothing I'm against that stuff. Because I know some people are really stupid. That's why my dogs, when they went, that's what we did. And I didn't plan on breeding them dogs because Rogan had only 1 testicle, and I would have a herniated, umbilical cord herniated, and it wasn't something she did, it was something Mom did when she was giving birth to her. But I did want to make sure their hips were okay, so and they asked me several times. I said, no, I just want to know the hips are okay. That's all I want to know. Actually, it turned out not to be okay, which is another reason not to breed. But I liked them and I wanted to keep them. I mean, those 2 dogs were the best dogs I ever had. Housebroken, crate trained within 4 months. They would run around the yard, like chase chipmunks, which tipped off one of my cats. I don't hurt dogs. I talk to him. He only would say, who are you talking to? I said, I'm talking to the dog. He was the only road truck driver. He wasn't home a lot. He was gone for 2 weeks and then come home for a weekend. So I talked to my dogs. That's all I had.
I think I've given you enough time to tell me what you wanted to tell me. As the prosecutor indicated, I did preside over the trial, so I heard all the evidence, saw the pictures.
And those pictures were made up. Okay, I'm sorry.
I gave you lots of time to say what you wanted to say. Now it's my turn, okay?
Okay.
I heard all the evidence and I heard all the testimony. I saw the pictures. And there's no question in my mind that you were not caring for these dogs properly. And that's what the jury found. And ultimately, in our system, the jury is the last word. And found that you were guilty. So I look at this as you have been convicted of this charge, so the only question is, what is the appropriate penalty here? And the thing that really strikes out to me is that, you know, you were convicted of the same exact thing in 2019 in Antrim County. And you were given probation, and you didn't change anything about what you were doing. You continued to engage in the same type of behavior with regard to these animals. And there's no question in my mind, they were being kept in those crates way too long. No dog deserves to be locked up like that for 22, 23 hours a day. And what that tells me is the first time you got in trouble for this, you didn't change anything. You didn't learn from it. You didn't decide to do anything different. You did the exact same thing, just in a different place. That tells me that the probation before didn't have the proper effect on you. And so in my view, there needs to be an additional penalty here so that you understand that this is wrongful conduct. You cannot do that with regard to dogs. You can't take care of that many dogs. You shouldn't have that many dogs. It's not fair to the
I have
animals.
6.
Yeah.
2 little ones and 4 bigger ones.
Yeah.
I can't. I've been doing it all my life.
Well, if I'm gonna believe you or a veterinarian's testimony, I'm gonna give a little more credit to a veterinarian's testimony about what the proper way is to care for a dog.
Yeah.
And I'm not gonna argue with you about it. The jury found you guilty. I think a short jail term here to kind of reinforce this message is necessary for you to learn that this is not the way to do things, and to hopefully prevent you from doing this again.
I have
Future,
doctor
if you want.
appointments. I have to get my hands
So the
taken
court is
care of.
gonna sentence you to 2 years of probation. The court's gonna adopt as the conditions of the probation, all the terms and conditions listed in the report. The court is gonna order that you serve 7 days in the Crawford County Jail. You do have credit for 1 day served. Crime victims assessment of $130. Court costs of $325. Attorney fees of $350. State cost of $68. You have the ability to seek an appeal of this sentence, and Mr. Trle, you can provide the appellate rights to Ms. Schultz.
So your paperwork, I need yours in the shoots right there.
I can't see.
Give me your glasses. Let's do this. Just for the record, Ms. Schultz has her.
Ms. Schultz, you can go with the officer now. You're in the county.
Just add one question.
Yes.
Ms. Schultz needs to grab, I believe, medications if she has them there.
I do have, I have several meds I heard.
Can you help her grab that? Or get it for Mr. Trle.
You have them meds?
No, I was told there'd be no jail sentence.
They're not in your purse? At home?
They're in the cupboard.
Yeah.
Okay, my prescription ones are in the box. And my insulin.
I bring them over to you.
Oh, God, the last time they did that, they messed up my insulin.
And Judy, I know she has some medical appointments. I don't know if the court would entertain any furloughs if she
I
has to
have,
make those appointments. I
Well,
believe her
we'll
husband
discuss
can
that
drive
later.
and.
I would need medical documentation from the doctor of the appointment.
Good.
Because I don't believe that Ms. Schultz. would be about that. So
Okay.
I would need medical documentation.
I don't understand.
I'll come back with you.
Please don't do that to my wrist. I'm having surgery on them. This is so bad. I mean, nobody would. I'm not joking. I'm not gonna run on you.
All right, Mr. Thompson, are you ready with Ms. Mellon's case, Jamie Mellon?
I'll see if she's in the lobby.
All right, thank you.
Ms. Mallon?
No response to that, Your Honor. It's in the lobby.
Okay.
I've not heard from, I don't know if I'm on the record yet.
Let's go on the record in that file. This is People versus Jamie Lynn Mellon, case number 235-217. This matter was set for hearing at 2:30. It's now 2:36. Ms. Mellon's not answered the, I'm sorry, two files. Ms. Mellon's not answered the call of the court. Have you had any recent contact with her, Mr. Thompson?
No, not since we were in court last, Your Honor. If she's, if she doesn't appear today, it might, it's possible she's late, but if she's not late, we do have a jury trial coming right up. So ask the court to address that. I know we have a busy docket that week. I don't know if there's alternate trials that day.
Your Honor, there are four. Oh, sorry. There are 4 jury trials that week. One of them has come off today, I believe. This one's not stacked. It's on Tuesday, February 13th. If the court wants to leave it on for a couple weeks to see if she's picked up, so I don't lose the date, that would be fine with me.
I would defer to the court's discretion, Your Honor.
Okay, I'm gonna set it for a show cause at, on the court's February motion day, full motion day. And then Ms. Mellon doesn't appear for that date, and we'll decide how to proceed.
So that's the week before.
Correct.
Okay. All right. Thank you, Your Honor.
And just to confirm, we're not doing a bench warrant.
Not today, I'll set it for a show cause on that date.
Okay.
This is her first. Appearance.
Mr. Grigsby is in the lobby. I can grab him.
Okay, please, thank you. So, set it for a show cause. February 4th.
Leaving it on.
People versus Grigsby, case number 235-221.
Your code to be after the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendants, Brian Grigsby. Your Honor, this remains set on trial track. You know, I've had conversations with the prosecutor. It's not being neglected in any way. We don't see the case the exact same way, and I believe it's going to have to be determined by a jury. I believe I'm all set on my case in chief, and I don't have any pre-trial motions for them.
Okay. Ms. Coe, do you have any issues that are going to need to be resolved prior to the trial date?
No, we are prepared for trial.
And I have this set for one day, on February 15th. So Ms. Coe, I'll just ask that you submit your proposed jury instructions specified in the pre-trial order. Mr. Thompson, you don't need to submit a full set, just whatever instructions you'd like that are additional to Ms. Coe's, or if you have any objections.
Would that be 14 days, Your Honor?
I believe so, yes.
Okay, I will have any proposed ones by the first time.
And Mr. Grigsby, it's just important that you stay in touch with Mr. Thompson between now and that trial date so that you're prepared to go forward on that day.
Yes,
I just ask that you're here and ready to go at 8:30 in the morning of February 15th, okay?
Yes.
Ms. Coke, anything further we need to address for today?
No, thank you.
Mr. Thompson?
No, Your Honor, we're prepared for trial.
Okay, thank you, Mr. Grigsby. That's all for today. People versus John Castle, case number 225060.
Sierra Coke can be after the people.
Thank you, Your Honor. For your hearing on behalf of Mr. Gassel.
Mr. Ayers, this is set for a motion to withdraw today. Anything that you wanted to state for the record?
Yeah, briefly, Judge, we had a breakdown for a little bit in our relationship. Mr. Gassel is doing well now. I did talk to Mr. Jaskowski, Mr. Thompson. Dylan Jaskowski is the underlying attorney, which forms a basis of this violation. I think it's a violation of state law. He's going to handle the probation violation, is my understanding. And I would ask to withdraw.
Mr. Castle, do you have any objection to that?
No, sir.
The court will grant the motion. Did you include an order with that?
I think we did, Judge.
I don't think so.
but if not, I'll get one to you. I thought that we had one in there.
Not one that I received today.
Oh, I do have one here.
Thank you.
I'll sign that one. So Mr. Ayers, you are relieved of your representation. Mr. Castle's file. Mr. Castle, you don't have an attorney. I know Mr. Ayers has indicated that Mr. Jaskowski is going to represent you. Is that by retainer or is he appointed in that?
I think it's gonna be appointed, is what Mr. Thompson was saying.
Okay, so the court's going to order that Mr. Jaskowski be appointed to represent Mr. Castle as part of the probation violation as well. And then the court will set this for another hearing date. Mr. Castle, you'll be notified of that date as well, okay? In about 30 days. This vote, anything that.
No,
Thank
Judge.
Here's a paper.
Good to see you, Judge. Thank you.
Yeah, like handwritten.
After finally get a break, it's okay.
For Ms.
Ms. Bowman? Can you please call for Ms. Bowman? Bowman?
Nicole Bowman.
Take a short recess, come back about 5 minutes. Sir, can you tell me your name there at the Department of Corrections?
Justin Brian Baker.
Mr. Baker. Versus Baker, case number 235250. The record should reflect Mr. Baker's presence today by video from Department of Corrections. If I could have counsel for your appearance tonight.
Sierra Coke on behalf of the people.
Thank you, Honor. Jason Thompson on behalf of Justin Baker. Your Honor, if I could just walk next door, grab my file.
Yes.
All right, thank you.
Oh, Mr. Townson, how did you want to proceed on this file today?
Thank you, Your Honor. We do have a plea offer in this matter, Your Honor. It would be a guilty plea to count 4, which is possession of less than 25 grams of a controlled substance in exchange for dismissal of counts 1, 2, and 3. So count 4, that's a 4-year and/or $25,000 penalty. It's been a little while since I talked to Mr. Baker because of his being quarantined when he went to prison, but I believe he may be interested in taking that offer. It would also result in the dismissal of the habitual offender, Your Honor. The prosecutor would preserve any restitution.
Ms. Polk, is that a correct statement of the plea offer?
It is and it's dismissal of the count 1 possession of methamphetamine, which is the 10-year. Count 2 resist and obstruct. Count 3 the receiving and concealing, and the habitual notice. There may be a request for restitution, but we contacted Avis and they aren't requesting it, so we have no additional information on restitution.
Great. Mr. Baker, were you able to hear all of that?
Yes, Your Honor.
Did you want to go forward with that plea agreement today?
Yeah.
Okay, can you raise your right hand, please? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Baker, were you on any kind of probation or parole at the time that this offense occurred?
No, sir.
And you understand that the maximum possible penalty you could face for possession of the controlled substance fentanyl is up to 4 years and/or a $25,000 fine?
Yes, Your Honor.
With that penalty in mind, what is your plea to that charge today?
Guilty, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses at your behalf, on your behalf, appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
And you understand that you're giving up and waiving all those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and that would be the end of any appeal of your plea. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor. I got a question though.
Sure, go ahead.
Before we go, like, finish with court, is there any way I can talk to my attorney about a couple things?
Mr. Thompson, do you have a mobile device here that is a breakout room with Mr. Baker?
Yes, on Zoom.
Yeah.
Yeah, I'll sign into Zoom.
Okay, so let's just hold off for right now. Let's take Ms. Bowman's matter and then we can sign in.
All right.
So Mr. Baker, I'm just gonna have you just wait just a minute there. I'm gonna take another quick matter and then I'll put you into a breakout room with Mr. Thompson so you can have a private discussion with him, okay?
All right, thank you, Your Honor.
Yep. I'm just gonna mute you for a moment here. People versus Bowman, case number 225062.
Here, go on behalf of people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Nicole Bowman. Your Honor, I did review the original request with Ms. Bowman, and then I was advised there's an amended one, so I did hand that to her. It just adds an adding count 3, which I think I had mentioned it, so I believe she's ready to go.
Mr. McDowell, did you have an extra copy of that for me? The one I have only has one alleged violation. Oh, no, maybe it's because there's 3 non-technicals, or 3 technicals. Okay, sorry.
It's a little confusing because this is the case where we set a show cause for 2 technical violations, and when she failed to appear for a hearing, then the third count was added. Okay, as a warrant.
Okay, got it. Thank you. So, Mr. Thompson, we just need to have Ms. Bowman arrange on this today?
Yes, please, Your Honor.
So, Ms. Bowman, have you had a chance to go through the alleged probation violations with Mr. Thompson?
I'm sorry, I didn't hear.
Did you have a chance to talk to Mr. Thompson about what the 3 alleged probation violations are?
Yes,
Okay, and you understand what they're alleging?
yes, sorry.
Okay. So a few things with regard to your rights. Number 1, you do have the right to have a hearing as to whether or not you violated your probation. You also have the right to have an attorney in subsequent proceedings. Have you been appointed on this, Mr. Thompson, already?
No, Your Honor, but if we continue, I will be.
Okay. So you have the right to have an attorney present at any later hearings, and Mr. Thompson's here representing you here today. If you are found guilty, because these are technical violations, the maximum penalty you can face would be up to 3 days in jail. You understand all those things.
To how many?
3 days.
3 days?
Judge,
I can speak. 5.
it's actually first technical on a felony charge is actually 15 days jail.
15.
This is actually her second technical. She already had another violation back in July for absconding or not reporting, and so this would be a maximum of 30 days jail.
Okay, thank you for that correction. So the maximum penalty you could face, Ms. Bowman, would be up to 30 days in jail. Do you understand that?
Yes, I understand.
Mr. Thompson, how does Ms. Bowman want to plead to these charges today?
Ms. Bowman, did you want to plead guilty or did you want to hear?
May I speak, Your Honor?
Yes.
Okay, so when I went to Bear River, it was on my own accord. The reason I got kicked out of Bear River was because there was a confrontation between me and 2 females that were trying to smuggle some stuff in through church. So that's why I got kicked out. It wasn't me or no trouble. It was just a confrontation from them. They were angry. They found out that I said something. My vehicle broke down when all this was happening while I was in Bear River. I've had trouble getting back and forth because of transportation. I have gotten that taken care of now. I got myself a truck. I just bought a house in Prudentville, brand new house. We're just putting walls in it and everything. I work at the Kennel Happy Acres in Roscommon, just started there a week ago. Like, my life is literally coming together. Mr. Mike, I'm very sorry. It's just the transportation. That's all it is. I've stayed clean. Even when I went to Bear River the second time, I've been clean since June 9th, Your Honor. I'm doing good. I swear to God, I've been clean. I'm very proud of myself for that. That's a big accomplishment in my life. But I'm scared that if I do this 13 days, it's going to set me back all over again. And I'm going to lose my job, my house. Like, I'm a new homeowner. I got stuff to brag about. I'm doing good. But
It's the transportation. And it's the fear of all this, of all my life falling apart again. I'm doing good. Is there any way that we could possibly maybe reduce it down to a little less time? Because I just started this job. They're relying on me. I work at a dog kennel, boarding kennel. It's my dream job. I love shoveling dog shit, sorry. But I'm finally where I want to be. I'm happy.
Yeah, I mean, I don't know what Mr. McDowell is gonna be asking for in terms of the penalty if you plead guilty.
I'm not asking
don't
for
know
any
if there's
penalty.
been-
I'm not asking for any penalty or pity either. I understand that I did mess up, and I promise you this go around. I got a brand new truck now, brand new house, steady income, everything. I can start as soon as Monday on my community service at the food pantry in Holton Lake. I already talked to the ladies and everything about it, so I can get that knocked off with my fines as well. I have it lined up. I'm trying.
Judge, I did make a offer to Mr. Thompson that if she plead guilty to not reporting, that I'd be recommending 15 days jail, additional jail, and discharge from probation.
Okay.
I don't want to get into the back and forth, but
I know.
How much credit does she have? So,
well, it would be 15 additional days, so she was arrested on the 14th, so she'd have 2 days credit.
okay. All right. So, again, if you want another chance to talk to Mr. Thompson, I'll give you more time to talk now. I can't tell you what to do. That's what Mr. McDowell is recommending.
That's all I have to say.
So did you want to plead guilty to that violation?
Yes, sir.
Raise your right hand, please. I swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Ms. Bowman, you were on probation here in Crawford County back on December 18th of 2023, is that correct?
Yes, sir.
And you were aware that you were supposed to be here for a hearing that day?
Yes.
And I understand the reason why you weren't here, but you did in fact fail to appear, is that correct? We need to be able to pick up your voice on the microphone.
Yes, sir.
Oh.
Sorry.
All right. The court finds that your plea is knowing and voluntary. The court is satisfied there is a factual basis to support a finding that you did violate your probation by failing to appear here on December 18th, 2023. The court will accept your guilty plea. Mr. McDowell, so you're recommending 17 days with 2 days credit?
I would recommend 15 days judge with 2 days credit and discharge from probation.
All right.
Really? Thank you.
That's anything you wanted to say on behalf of this one?
Thank you. I know Ms. Wilman's already said it a lot. She describes that she was having a lot of difficulty with transportation, and that caused her having trouble being able to report in person. She advises she made efforts to stay in some amount of communication with Mr. McFalda, that she has been clean. She appears much healthier than when she originally entered the plea in this case. She's obviously very excited about the things that she should be excited about in her life, about how home, about a job. This is really a lot of positive momentum. She's asked the court to temper its ruling in light of all that. Thank you.
Ms. Bowman kind of already told me a lot about your circumstances. Was there anything else that you wanted to say? All right. I think what Mr. McFeld is recommending is inadequate penalty for your failures on probation. The court is going to be set to discharge for probation as well.
Yes, Judge.
So the court is going to sentence you to 15 days in the Crawford County Jail with credit for 2 days served. The court is going to discharge you unsuccessfully from probation. The court will preserve any outstanding fines, costs, so you need to make payment of those. Go forward. You do have the ability to appeal the sentence, and you probably don't have appellate rights for Ms. Bowman.
I don't see that they're up here, Your Honor.
I can judge, I can run those. I did not know who was doing this, so.
Okay.
No problem.
Okay, so Ms. Bowman, the court's going to provide you with your appellate rights. And all those papers will be how to appeal the sentence if you want. Anything further on this file, Mr. McFell?
No objection.
Mr. Thompson.
Nothing further.
Is it actually, she just wants to hold on a minute?
We'll get those to you in the hallways. Good luck to you guys.
Or want me to check in with Mr. Baker?
Yes.
All right, thank you.
Okay, Mr. Baker, I'm gonna put you into a breakout room with Mr. Thompson now.
All right, thank you.
All right, well, that's going on, Mr. Germer, are you ready on Mr. Stump's case? What's your name, sir? Ready on that one?
Not my time, Judge.
Oh, I'm sorry, that's Mr. Thompson. Okay, yes, are you ready on Mr. Scarborough?
I'm ready and I. Update the court.
This is People versus Travis Scarborough, case number 235.
Your copy of the people.
Thank you, I don't have your ready here for Mr. Scarborough. Mr. Scarborough is not present in the courtroom. However, I've had contact with Mr. Scarborough. He is currently in a ditch on a road. And I asked him to please download Zoom. So he's here and the court can see that I don't know if he's on Zoom or not.
Okay.
But he's kept in touch with me. He's called me a couple of times while we've been waiting for his matter. So we're trying to figure out if Mr. Scarborough is able to make the court.
See if he's hereby closing or not. If he's not, your prosecutor will decide how to go forward. Again, please don't tell your clients that they can call in on.
Okay.
If it's set for in person, I can hear from them on Zoom anyway.
Okay.
I've told counsel this before, please do not tell your clients to appear by Zoom.
First time to me.
They're either here or they're not here.
Okay.
But having them appear by Zoom is.
Okay, I'll let Mr. Scarborough know to try and make it over here.
So, Mr. Stump, you just wait there as soon as Mr. Thompson's done with his other client. It's okay.
Judge, I have a receipt of this vote.
Mr. Baker and Mr. Stump. So I just talked to Mr. Baker. They'd still be in that breakout. I left it.
Okay. Might take a second, but it's being transferred back. All right, Mr. Baker, are you able to hear me?
Yes.
Did you have an adequate opportunity to speak with Mr. Thompson?
Yes, Your Honor.
All right, are we continuing with the plea here, Mr. Thompson?
I believe so, yes.
All right, Mr. Baker, did you want to continue with entering this plea today?
Yes.
All right, so I went through your rights with you, and I believe the last question I asked was whether or not anyone's threatened you with anything to get you to plead guilty today. Has anyone done that?
No.
Has anyone promised you anything other than what we've said here in court on the record?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes.
Information I have indicates that this happened back on February 4th of 2022. That's almost 2 years ago. That's a while, but do you still remember this incident?
Yes.
Okay. On that date, were you present here in Crawford County?
Yes, Your Honor.
While you were here in Crawford County, did you possess a controlled substance that contained fentanyl?
Yes, Your Honor.
And did you know that that's what that substance was?
Yes, Your Honor.
Do you have any legal right to have that at that time?
No, sir.
Thank you, Ms. Koch. Are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Thompson?
Yes, thank you.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your
Mr.
Honor.
Thompson?
Nothing else, thank you.
And Ms. Koch, are the people satisfied that the court has complied with statute and court rule and taken it?
Yes, Your Honor.
Yes.
Mr. Baker, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Mr. Baker, you do have the right to have that hearing in person, to be here in the courtroom in Crawford County. If you wanted to.
Yeah, can I do that?
I'm sorry, what's that?
Yeah, can I be in person for that?
Yes, so the court will have that set as an in-person hearing Ms. Culp, if you can prepare a writ for Mr. Baker to be transported here to Crawford County for purposes of sentencing.
Yeah, sure.
Anything further on this file today, Mr. Culp? Mr. Townson.
No, Your Honor, thank you.
Thank you, Mr. Baker. That's all for today. Do you have any questions at all?
Do you know what day of next month my court date would be by chance?
I don't know. I can't tell you what date it'll be, but you'll be provided with notice of the date and time of that hearing.
Alrighty, thank you.
Okay. People versus Derek Stump, case number 235258. Mr. Stump, if you come around to the podium here, please. The record should reflect Mr. Stump's present here in the courtroom today. That's counsel for your appearance.
Sierra, welcome back to the people.
Thank you, Your Honor. Jason Thompson, I have Derek Stump.
Thank you. Mr. Stump, have you had a chance to go through the pre-sentence report with Mr. Thompson?
Yes, sir.
Mr. Thompson, are there any additions?
There are not, thank you.
Are there any challenges to the scoring of the guidelines?
There,
People have any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
People have any victims that wish to address the court today?
Not that I'm aware of, Your Honor. I think this is appropriate. Frankly, there was another case in Jackson that got dismissed, and then they went on camping. I don't even know how they got themselves into this situation, but Mr. Stump's behavior was completely inappropriate, and I think the recommendation for 10 months with 128 days is appropriate. Thank you.
Your Honor, I'd ask the court to consider a temporary recommendation here. Mr. Stump's got a background. He certainly has a mental health condition that he is working through and he's trying to address. But this wasn't incident involved, family and people that thankfully nobody was hurt in this incident. Mr. Stump has taken responsibility, asking that the court consider all the circumstances here. Perhaps consider a 6-month jail term. It's perhaps more in line with the facts and circumstances of what occurred. Thank you.
Mr. Stump, was there anything you wanted to say today?
No, sir.
All right. I did read through the report, so it's clear that this incident that brings you before the court here today. There's also a lot of information in that report of yourself and your circumstances in your past history. Certainly one of the things that concerns me is your history of assaultive offenses. You have quite a few assaultive offenses on your record. So far, none of those have risen to the level of a felony until now. But it is something that you do need to get treatment for. You do need to seek out some help on your own to deal with whatever's causing you to react this way to situations, because otherwise you can end up spending more and more time in jail. You're still a young man, you're 33 years old. I don't think that's a place you want to be. So it's in your own interest to get some help for this. The guidelines in this case are 2 months to 17 months. Potentially called for prison time. I don't think that's warranted given all the circumstances here. But I do think a jail sentence is justified by your conduct and your past record. I think the recommendation is right in the middle of the guidelines. I think it's reasonable. I think it adequately, again, accounts for your conduct in this case. The court is going to follow that recommendation and sentence you to 10 months in Crawford County Jail. You have credit for 128 days served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $395, attorney fees of $350, and $68 state fine. You have the ability to seek an appeal of this sentence, and Mr. Thompson will provide his appellate rights.
Thank you. He has initialed that.
You received further that you want to address at this time.
Thank you. No, thank you.
Nothing further. Thank you.
Matters with Mr. Ellison at 3:30. I did get a message that Mr. Seeger might be running late. He had a hearing for the time. Mr. Seeger's here too. run the record in People versus William Alexson, case number 235-248. If I could have counsel put your finances on, please.
Sierra Coke on behalf of people.
Thomas Seeger, family Thank you. We're set for a couple hearings, motion hearings in this case. Mr. Seeger, you filed a motion to exclude the admission of body cam footage into evidence, as well as an objection to Ms. Coke's 404B notice. I did have a chance to review your motions and the supporting materials, and Ms. Coke, I did receive your responses. I had a chance to review that as well. Mr. Seeger, if you'd like to proceed first with the motion as to the body cam.
Your Honor, I basically objected to it because I generally didn't find it to be relevant, and my primary concern is that I don't want it to be used with that. In certain portions, he exercises his right to remain silent, and I don't feel as though that would be appropriate. I feel as though they could use still photographs to show where the items were allegedly found. I'm not really disputing that he was driving the vehicle, as there's someone alleging in their brief, because he was driving the vehicle. I'm not specifically alleging that his license plate was improperly fixed, or wasn't some problem with his license, all of which can be proved in different ways. So I'm not really sure how it adds to anything in terms of the body cam, but I'm primarily concerned about him having the right to exercise his right to remain silence, and that silence being used against him just by virtue of the view.
All right, Ms. Coke.
Yeah, the people only intend to admit 10 minutes, which I attached, I redacted and attached. And there's plenty of case law, courts probably very familiar with it, but you know, the people may admit defendant silence during non-custodial questioning in the case in chief, unless they specifically invoke his Fifth Amendment right not to incriminate themselves. There's half a dozen different cases that talk about it. He actually does answer most of the questions. I think just a couple of them he doesn't answer. I think it's important for the people to be able to watch the videos while the officer can testify. The jury does not have to believe the officer's testimony. So there's no reason why I wouldn't play that. This isn't like the case that's cited here. I'm not trying to bring in 4 different views of the same evidence or even the entire video. Just the points that are relevant for me to prove each element of each charge. Thank you.
Mr. Seeger.
Well, I mean, I guess the jury can decide how to believe any one particular witness, but I do find it somewhat rich that there is a restriction that specifically addresses law enforcement, such that our legislature decided that we need to create an instruction where it essentially says that law officers' testimony is no greater than that of an ordinary person. So I think even with that instruction, and either in fiction of the quote unquote curative instruction, I think there's still a presumption, or at least it would be my position, or believe that people still give law enforcement somewhat of a superior belief as opposed to an ordinary citizen. And I'm not really disputing, and they would have to prove other objects, like in terms of whether or not his license was suspended. Or to do that, the officer can't probably specifically testify about that. And there are other ways that prove that. So I just don't see what it adds.
Okay. All right. As counsel's aware, under MRA 401, relevant evidence is any evidence which tends to make any material issue more or less probable. The evidence has to have probative force. That means it has to have a tendency to either prove or disprove a matter at issue. It has to be material. In other words, it has to go to something that's important. Issue that is in dispute in the case. The court finds that body cam footage is relevant. It does tend to prove or disprove whether Mr. Alexson is ultimately guilty of the allegations. I think it's also relevant as to credibility, to the extent it either supports or does not support the testimony of the officers involved. So the court finds it is relevant to the extent that it does contain any statements by Mr. Alexson in terms of invoking his rights. I think a limiting instruction would be appropriate, and at the request of the defense, the court would provide that instruction to the jury after before and after viewing, and if you are going to request that instruction, if we have trial in this case, Mr. Seeger, I would just ask that you submit that in advance. So the court denies the motion with regard to to exclude the use of body cam. And then the next matter, Mr. Seeger, is your objection to the prosecutor's proposed submission of evidence regarding the prior issue with regard to methamphetamine use or possession. So anything you'd like to say?
Your Honor, I mean, I would largely rely on my brief and motion, but generally speaking, I would just say that I believe that the propensity evidence to the extent that they need prior conviction to prove their case. I think that's probably somewhat telling in terms of like how strong the proofs are or aren't. So be that as it may, Your Honor, just looking at the cases, the only thing that I can see that it's maybe somewhat factually similar between the two cases, one is an allegation. It's related to him operating a motor vehicle, which I don't find to be positive one way or another. Not really clear to me how that would show intent or anything. Cars all the time. Nothing new or strange or unusual. That shows that whatever it was that was allegedly in his car belonged to him. Actually, in the other case, that's where on his person in contact when allegedly they were found on the plate and they were residues. So in one instance, it's a case of found actual methamphetamine on his person, whereas in this case there was residue on a plate, which is one two, and the former instance, it's on his person in his pocket, whereas in this case, it's an argument of possession. I don't see where, I don't see a causal connection between the two. The only thing that I can come to is the conclusion is essentially I'm basically saying he did it for his own. So they're essentially trying to try a person, not the case itself. And even if it were relevant, you're not going to say that over value itself, their prejudice. So
We filed a brief in response to the objection. I cited multiple cases where this is allowed. The court is familiar. I mean, just in this county, I know this court presides over 3 counties, but we try possession of meth cases all the time. So I know this court's very familiar with what I have to prove and what the elements are. Factually, this is extremely relevant. This happened very close in time. This isn't a super old conviction. And I detailed why I thought the cases were factually similar in my brief and all of the case law I thought that supported my position. Thank you.
Mr. Seeger, anything that you wanted to say?
Your Honor, just again, that I believe it to be propensity evidence, and I think that if they're able to establish that the vehicle is his, then they can deal with their own proofs without the assistance of having which again, I think the two cases are substantially distinguishable. It's not really telling in my mind, how close they are in time. And I guess to the extent that if the court thought that it was admissible, I would probably have to name John Haven as a witness who, when I had spoken to Mr. Haven had indicated that Mr. Ellickson has tested negative for all substances during the course of his probation. So, one, I don't think it's admissible, but then I guess I would have to use it for one witness. So it's I don't see a causal connection between the two. Definitely more prejudicial. I don't mind having the trial, Your Honor. I just assume it's fair. I'm not saying the court is unfair. His rulings are. I feel like that's an unfair advantage to the prosecution. They are relying on something that happened in the past as opposed to what happened in this particular case. If they can't prove it based on the things that happened in this case, there's not some superior reason why it should be admitted.
I reviewed the briefs. I looked very carefully at the prosecutors seeking to admit that evidence as well as the similarity between the two cases, whether or not evidence of the prior incident is logically relevant to what happened in this case. And that's what the court has to find. The court has to find not only that the prosecutor is seeking to admit it for a proper purpose, but that it's actually relevant to that purpose and not to simply propensity. In this case, the court finds that there are enough factors that are dissimilar between the two instances. Even though the prosecutor, I think, has put forward a proper purpose, I think what's going to happen in this case, if that evidence is admitted, is it's primarily going to end up going towards propensity. I don't think there's enough similar facts between the two cases to show purposes that the prosecutor is seeking to admit the evidence for. And I've had prior cases, I think drug cases in particular are difficult. I've had prior instances of drug use, drug possession, case that represented where the court did admit evidence of prior drug dealing in a vehicle. Deals indicated that while the prosecutor had proper purpose, the fact that the defendant had previously sold drugs out of a vehicle was not similar enough to a delivery case. The case that prosecutor was seeking that evidence was not similar enough for the prosecutor to be able to show that it wasn't just for propensity. In other words, the fact that the individual had been selling drugs out of a vehicle, a prior case had been convicted of that, didn't mean the fact that he was selling drugs out of a vehicle again tended to show that it was a common scheme or method or lack of mistake or something like that. And I view this in the same kind of light as that. So the court finds there isn't a sufficient nexus purposes enunciated by the prosecutor here and the private incident to make it admissible under 404B. The prosecutor can get in under some other rule that may be, but as the 404B, the court is going to grant the objection and rule that it's not admissible for the purposes stated by the prosecutor. So, Mr. Seeger, if you would prepare an order that reflects both those rulings.
Your Honor, I attached blank motions to both of my responses for the court. That should be done.
Do you mind if I, did you see Ms. Coates' forms?
No.
They're just,
Ms. Coates suggesting that I use her proposed orders.
Yep, that's fine.
You're okay with that form?
Yes, sir.
Okay, so I'll enter those orders. Ms. Coates, anything further on this case today?
no, thank you.
Your Honor, would there be one final settlement happening somewhere, just trying to determine whether or not we want to deal with resolve? I don't believe so.
This is the
If I
only,
do, I haven't received notice.
this is the only hearing that's on the docket.
I do have it listed. We had a pretrial hearing back in November, and the court will set this. I have it listed this set at least 90 days out in November. So, and I also have it set to have a final status conference immediately prior to the trial. So there will be one more hearing prior to trial.
Thank you.
That's all. Thank you, Governor.
All right, please.
Sorry to keep you after hours.
No, you're on my docket. It's when they're not on my docket and they added.
Yeah.
This one I knew was good.
No, and when I pulled up the case docket, we weren't listed on it, so
Oh, yeah,
at least it's on yours.
it's on mine. It's an extra page that was put on it.
Yeah.
I didn't know it this morning until I come over here to cover for the other guy that left. Nice. Oh, there is none.
Well, if it helps anything, we drove 1,900 miles through 2 blizzards to be here for it, so.
Well, tell you the truth, it don't make no difference to me. I get paid whether I'm here. I'm here, I get paid. If I'm not, I don't get paid, so.
There you go.
A little extra time, that's just fine.
Plus it's warmer in here than it is out there.
Yeah, we left 87 degrees, so we're 120 degrees colder than when we left to come here.
Oh, yeah?
Yeah, we came from Key West, so.
Oh, yeah. Well, I got a big chuckle out of it, because we were down to, my nephew and niece is down in Alabama last month. And I looked at their weather yesterday and they were getting snow down there.
It's just amazing.
So I laughed at them.
Yeah.
Yeah.
Oh, yeah.
It's your turn.
I was all blown snow the last 2 days, but they weren't going anywhere.
I was just gonna say, I would have shut that whole state down
Their
there.
governor shut their state down.
You know?
Yeah, at least we got up and got a day of snowmobiling it yesterday.
There you go, yeah. Well, this whole weekend we had a bunch of them running, so.
Oh, it was crazy.
Yeah.
Yeah.
Yeah, they were everywhere this weekend.
And finally, I mean, it's been a long time coming.
Yeah. Been a long time since we had enough snow to really enjoy it here.
Yeah. I feel sorry for these judges that just gotta keep running around why don't they just do one county every day and?
Yeah. Well, this judge has got 3 counties.
Yeah, just and back and forth every day in between them. It's just.
Yeah. So, yeah, you got 3 counties. My district judge has only got this one. You got 2 judges and they both got.
Updates when I need it. My stakes in case there's a lot of ice, you get all your stuff in there.
All right.
First one to come forward, Mr. Gorst, you have to sit on that table, Mr. For you and your client. On the record in the Gordon Kurgaski versus Gunn. This is case number 2311370. Seated. Present here today. Mr. Gunn's also present. Represented by counsel, by appointment. This is set for hearing on an alleged violation of the personal protection order in this case. So, Mr. Kurgaski, the way we're going to proceed today, the court's going to place you under oath, have you testify as to what you believe is taking place that is a violation of the personal protection order. Mr. Mertz, on behalf of Mr. Gunn, will have an opportunity to cross-examine you, ask you questions. Do you have any other witnesses that you plan on calling today?
No, Your Honor.
Okay. And then Mr. Gerber, you'll have an opportunity, obviously, to call the witnesses on behalf of Mr. Gunn.
Correct. The only individuals I intend on calling, depending on how the testimony goes, are the 2 minor children from Mr. Mann who are witnesses. It again depends on what Mr. Kurgaski testifies to.
Okay. And Mr. Gerber, just so you're aware, because Mr. Kurgaski is not represented, I'm going to allow him to testify in the form of narrative. But obviously, you'll have the opportunity to cross-examine him if you need to. So, Mr. Kurgaski, if you come forward, please, and then we can stand here. If you can raise your right hand, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Thank you. Please be seated. And so, Mr. Kurgaski, the court granted this hearing based on a paper that you filed back in August. That was August 22nd of 2023. And in that you reference some incidents that took place on May 15th and May 17th that you believe were violations of the personal protection order. So can you tell me about those 2 dates and what you witnessed that you believe was a violation of that order?
And August 1st also, Your Honor, would be.
Okay.
And if you don't mind, if I can just grab my notes.
Yes, you can grab your notes, but I'm going to have you testify first, if you can, by memory, and then if you can't remember, let me know that.
Yes, Your Honor.
So just to explain to you the kind of the process, Mr. Kurgaski, you're allowed to review your notes to refresh your memory, but you can't testify just right from your notes.
Yes, sir. So starting in May, the defendant, Mr. Gahn, when I returned to Michigan and to my place of business in employment, which I own, which is the motel and restaurant in Levels, started coming by repeatedly, blasting music in his truck, slowing down, giving me the finger as he drove by, coming on to the property, my property repeatedly. And we do share a property line, which, so, and I understand. So he's never not going to be within my side of view. Or, you know, we're not going to be in a close proximity, which I understand that. But with the previous case, which he has already pleaded guilty to, and had been sentenced for shooting out my tractor windows, after repeatedly before the.
I don't want to object as to relevance, that doesn't go to the dates that are in question.
I'm going to allow Mr. Kurgaski a little leeway here because he is unrepresented. Mr. Kurgaski, to the extent he can, what I really need to know about is what happened to get you to file this show cause for violating the order. So and the other thing too is I presided over that other case.
Yes, yes,
I'm already aware of some of what's gone on between the two of you. So don't really need you to recap that. You just stick to what we need to talk about today.
So he repeatedly tried to continually tried to scare me. Coming onto the property, coming close to me, intimidating me, intimidating my clients at the motel, and mostly all in just intimidation procedures. I repeatedly went to the prosecutor and called the police to let them know what was going on. And then on August 1st, it is when it really escalated, when Mr. Gahn came within literally inches of me in his vehicle when I was on my property. And Your Honor, I'm not saying that he tried to hit me, but he came as close as he possibly could. I called the sheriff, and the sheriff came out and said they were going to send this to the prosecutor. The prosecutor at that time, for whatever reason, did not take action and said that I should take action myself and proceed to file the paperwork to come to the hearing we are at now, which I have video evidence and picture evidence to present to you, so you can see that. It has not stopped. Literally, Your Honor, today, when I went out to use the restroom, sitting in the courtroom and came in, he started laughing hysterically in my face, coming back into the courtroom today. I'm sure that's on video evidence and surveillance out in the lobby. He just does not, under any circumstances, want to relent from intimidating myself, my family, and quite frankly, the customers in my business.
What kind of media do you have, the video?
I have a video card that we made of videos, and I also have still photos to present.
Okay. All right. Why don't you show the still photos to Mr. Gerber?
Absolutely, yes, sir.
Yes.
And Your Honor, while they're reviewing those, I will say in the videos, I'm sorry.
Let's hold on to one second.
Yes, sir.
All right. I'm going to ask you some questions about those photos. If you can be seated again.
Yes, Your Honor.
I'm going to have you hold on to those for right now.
I'll stipulate to the admission if you want, if that's what you're asking, Judge.
Yeah, okay.
Yes, I'll make that easier, yep.
All right, so, I'm sorry. I'm getting closer. Plan for petition. And then he says it's group as petitioners exhibit A, parts 1, 2, 3, and 4. A1 through A4, and then if you can refer to them, you already kind of have a number.
Yes, sir.
Or so if you could just refer to the number. You're asking if you want to tell me what those photos depict. And, why
So
they're relevant.
Your Honor, in photo number 1, you can clearly see that I'm spraying weeds in my parking lot. The defendant's truck is going by the road. His driveway is about 35 feet past this point. where he would turn up to go up a road to his driveway. You can see that I am looking down in this photo, spraying weeds, unaware that a car is coming up, and you know, it's County Highway 612 in Levels, downtown Levels, so it's a busy road. So, you know, to hear a car that's coming on the road, it wasn't arousing to me that there was a car coming by.
Okay, and I just want to clarify a few things for my knowledge.
Yes, sir.
So the person in the reddish kind of shirt.
That's me.
Is there somebody else next to you, or is that something?
No, that's my, I'm spraying weed, so I have a weed spraying container. And this is the defendant's pickup truck.
White truck with that black line.
Yes, sir.
Across it. Okay.
And this building here is the front building on my property. So that would be the restaurant and store building on that property.
All right.
In photo number 2, you can see, because my position hasn't changed, but this truck now, the tires are no longer, these tires are no longer on the road. They're on my property with the outside tires being on the road. Here I am, I turn because this vehicle is right on top of me. And I turn and I look directly in that window with Mr. Gahn reaching across one of his younger sons, sticking his middle finger out towards me. And then photo 3, you can see my right leg, I'm trying to come back. Again, his tires that much further closer to me, and I'm trying to back away from the truck as he goes by. And again, all the reference, same camera, same photos, you know, same photos from the same camera. And you can see my shadow on the truck, how close he is to me. And then in 4 is just the same of all 4 of them, to, you know, to show the same photos in procession.
And are these screenshots from your video?
They are screenshots from the video. Yes, sir.
All right, thank you. I'm gonna admit those photos then, since they're screenshots from the video, and I don't think we have a way, and Mr. Gerber wouldn't be able to view that video. I'm not gonna do that, but these are screenshots from that.
And in your honor, also on the other videos, there's just several videos that show Mr. Gahn's behavior when I'm present at the property, how he goes by, how he pulls over and stops when I'm there. And then a few other videos that show when I'm not at the property, his behavior of turning in to the property and how he reacts are 100% opposite. The video shows that it's when I'm there, he has a set of behavior of how he drives and what he does, and when I'm not present, how he drives in the property and what he does.
Okay. All right. Setting aside the videos for the moment, is there anything else that you want to tell me about since either in May on August 1st or any other incidents that you believe would be violations of the order?
You know, pretty much, Your Honor, he has gone out of his way to do everything he can to intimidate me throughout the entire process of the court proceedings and up to today in the lobby of the courthouse. It's been continual, nonstop. I have done everything to the point of the law legally to have boundaries set. I have paid to have surveys done to the cost of thousands of dollars to make him happy, to understand where the property line is, which shouldn't matter whatsoever. Doesn't matter to me where the property lines is. What matters to me is being a good neighbor to everybody. And he just continuously harasses and intimidates myself and my family to the point I've had heart problems. I've been a cardiologist. I'm on medication. I've never been to a doctor or been on medication in my life because of what this man has done. And it's like living in a terrorist state. It doesn't stop. It just doesn't stop for any reason.
Thank you. Mr. Germonti?
So Gulaski, this is Highway 612, correct?
Yes, sir.
And where the truck is that the shoulder of the road?
No, sir, that is my property.
Are there property lines, stakes in the property there?
Yes, sir, I have stakes in the property because I have paid to have the property line staked out.
My question was, in those photos, do you see where the property line is, or are they stakes in that picture?
There are not stakes in the picture.
Okay, so that picture doesn't show where the property line is that
It does
correct?
not.
Okay. Were you throwing nails on the side of the shoulder?
Your Honor, I object to that. I have never thrown nails on the side of the shoulder, ever, never.
All right, I don't think that's an objection. You're saying that didn't happen.
That did not happen.
So you don't throw nails on the shoulder or on the driveway where Mr.
That's a repetitive question. I have never thrown nails on the side of the shoulder.
You've never thrown nails on the drive when Mr. Don turns.
That is correct.
You in this personal protection order, at least the violation, you indicate he stops and turns his music loud.
Yes, sir.
Does Mr. Don have a mailbox at the end of that driveway, that shared driveway?
No, he does not.
There's no mailbox there at all?
No, sir.
Okay. You indicate that Mr. Don intimidates you.
Yes, sir.
He's never walked into your motel, correct?
He has walked repeatedly on my property across the motel. So are you talking about inside the building or on the property?
My question was clear. Did he ever walk inside your motel?
He has not walked inside the motel.
Has he ever called you at the motel on a phone?
No, sir.
Okay. You say he's come onto your property. Has he parked in one of the parking spaces in your property?
No, he came on it on foot.
Okay, when was that? On May 15th?
On many occasions.
I'm just asking on May 15th, was he there on foot?
He has come on to the property on many occasions. I can't tell you exactly on May 15th.
Okay, so my question is, if you don't recall, if he came on foot on May 15th, you don't recall.
No, I recall him coming on and it's on video, and it's also on video on the past cases that I've submitted to the court.
Okay, my
That he has
question,
been on the property many times.
sir, my question is very clear. On May 15th, was he on foot on your property?
I don't recall May 15th
On
exactly.
May 17th, was he on foot on your property? Yes or no, sir?
I'm going to say on vehicle, not foot.
Okay, on August 1st, was he on foot in your?
No, he was in vehicle.
Okay, and he was in your parking lot?
Yes, he was.
And you don't have any pictures showing where the stakes are in the ground, determining where the property line is?
I do have stakes on the ground determining where the property lines are. They're just not in the photos.
That's what my question was. They're not in that photo.
That's correct.
Okay. I have nothing further, Judge.
All right, thank you, Mr. Gergaski. I'm gonna have you step down at this point.
I'm gonna call my client, Judge.
You solemnly swear or affirm the testimony you're about to give. Nothing but the truth, so help you God.
Absolutely, yes, sir.
Please be seated.
So, state your full name for the records.
Arthur Wilhelm Gann,
Spell your last name.
Gann, G-A-H-N,
Mr. Gann, where do you reside?
6638 Railroad Grade.
Okay. Is that off Highway 612?
Yes, sir.
Okay. Judge, if I may approach with the scriptures.
Yes.
Mr. Gann, let's show you what's been marked as Exhibit 1. Could you explain to the court what that picture is?
That's me driving home. Well, I'm coming home from in town.
Okay, and where is your truck?
It's on the shoulder of the road.
Okay, and is that your understanding of where the stakes are, which marks Mr. Gulaski's property line?
No, so there's no stakes in the front of that building.
Okay.
There's no stakes by the road. Actually, you can actually tell by the pictures that from the white line in the center of the road to the pictures I have and these, that it's 32 feet is right away for the county, the plot. That's public property. We have always used that shoulder, always, even going out, because when we go out, the corner, if you look to the right leaving, you can't see anything coming. And that corner is a bad corner. He's correct. That's a bad road right there because the 18-wheelers come flying through at 50 miles an hour. And from that corner, when they pop around that corner, there's no way that that truck can stop before he gets to the driveway. So when I pull out, I always pull out on that shoulder to use my mirror to see if anything's coming around the corner before I pull out to go. And I'm using the shoulder. I don't run on nobody's property. I've always used that shoulder. The man lives next door to me, uses the shoulder. I've used that shoulder for 3 years. There's never been any complaints at all of using that. I've never changed any way I drive. I drive the same way every day for the last 3 years. And we've always used the shoulder of that because that corner's so bad. You've got people coming up behind you. That's just a courtesy thing. You move over, let it go. So that way you're not impeding traffic.
So in that picture, are you, which direction are you heading?
If you go up about another, I don't know, 18, 20 feet, the corner of my driveway is right on the other corner of this building.
Okay. So why do you pull into the shoulder?
I pull into the shoulder to let people go past me. Because there's usually, there's always somebody behind me when I come around that corner. And not always, but most of the time. So it's just an automatic thing. I pull off into the shoulder. As I'm coming around that corner, I always pull off on the shoulder. And then I turn into the driveway because the driveway's right there.
Do you stop at the end of your driveway?
Sometimes I do to pick up the mail. There is a mailbox. Yes.
Let me ask you the questions.
I'm sorry.
Is there a mailbox at the end of the driveway?
Yes, there is.
And how do you drive up to the mailbox and stop and get mail if you expect that to the court?
If I'm coming up in his picture, I pull into my driveway and then back up and back out on the shoulder. On the other side of the driveway is where the mailbox is. So the mailbox is not on his side, it's on the other side of the driveway. And there's 3 mailboxes, one of them is his. And me and the man that lives above me, our mailboxes is right next to his. And so they're all 3 on one post or 2 posts with a board across it. And it's got 3 mailboxes on it. I pull in the driveway and back out and then back up to the mailbox, pull out, get my mail, shut the mailbox, put it back in gear and drive, and I pull to the left now, going up the hill into my driveway.
When Mr. Krugoski says there's no mailbox at the end, is that correct?
No, that's not correct. There's a mailbox on the other side of the driveway.
And one of those mailboxes is his?
Yes.
Okay. I want to show you the other 3 pictures collectively. If you explain to the court, is that the same thing you're doing with these other pictures, just turning?
Yes, that's it. It's actually the same day.
Okay. At some point, there were some nails on the shoulder, correct?
Yes.
Do you know how the nails were on the shoulder?
Yes. My oldest son come running up and he went down, he had an appointment. And he went down to catch the dollar ride. And my son watched him throwing nails on that shoulder where the dirt is. So he come running up to the house right away and he said, Dad, whatever you do, when you leave, don't pull on that corner on that shoulder. I said, why? He said, there's nails all over it. He said, I just seen Bill throwing nails on it. I said, Bill did that? He said, yeah. I said, okay. I said, well, I'll go down there and get pictures of it and I'll pick up the nails. So I went down there a couple days later. I don't get out very often. I spend 70% of my time in bed. When I did get out, I got out a couple days later. I was feeling pretty good.
Let me show you these 3 pictures that I'm gonna ask them to refer to them collectively. What are those pictures of?
These are the pictures of the nails that are on that shoulder that he threw down on me.
Should I ask that these be marked as respondents? I did.
Your Honor, I object to those photos. Those are photos that could have been taken at any driveway, any side of the road, any place in the world. They do not show nails outside that area exactly.
Okay, and those are all reasons why they might not have a lot of weight, but that doesn't mean they're not admissible. And I'll give you a chance to ask, you're gonna have a chance to ask Mr. Connie questions, and you can ask him about these as well.
I would ask that they collectively, 4 of them be marked as respondents A, Judge.
I guess, no.
Hold
on. I mean, I can admit all 4 of these. But, okay, if you want to admit all 4,
I just think collectively they show the nails and the gravel on that side there, Judge. Judge, and I can have them on.
or that this is the fence.
Mr. Gann, are those the pictures of that shoulder?
Yes, sir. The reason why there's 4 of them is because I was taking it like this, like this, like this.
Okay. And are those pictures from some other driveway?
No, sir.
And those are pictures that you took?
Yes, sir.
Those are the driveway where you're going to go up your driveway?
Yes, sir. And the other pictures.
Well, hold on. Ask your questions.
Okay.
It's a process.
Your Honor, I object to these questions. They have no bearing on this case.
Well, again, I mean, you can argue that they don't mean anything, or that the answers aren't probative, but they're the proper questions. So I'm gonna allow the questions.
Mr. Gann, would you tell me what that picture is of?
That's a picture of mine and other people's tire tracks on that shoulder.
Okay, and is that the shoulder that you used to turn up your driveway?
Yes, sir. And you can also see in the pictures where the lines are, and that's clearly not 32 feet from the shoulder, or from the center of the road.
Okay. Judge, I ask that this be admitted as respondents E.
I'll admit that as E.
Mr. Gann, would you tell me what these 2 pictures are of?
Same area, but I backed up, got back inside the truck and took the pictures at a different view to show you that that's the shoulder of the road. And he has a trailer out there, he puts the snowmobiles in, and the snowmobile trailer, you can see that if you back the truck up to it, hitch it up, there's no way a truck would fit in there up to that white line and go over past the white line. So the very front of that trailer, the very tip of that trailer is actually on county property.
Would you explain to the court how you drive and where do you drive to come up into your driveway?
When you go into Levels, when you head into Levels, going towards Lewiston, that's the corner right there. There's a little store on the other side of his trailer. And then there's his place. I mean, they're right adjacent to each other. And then there's our driveway. And when you come around the corner, I come right around the corner this way. And I watch my meters because usually there's somebody behind me. And I pull over on that corner right there, right where my finger's at. I pull over into the shoulder and get into the gravel and then turn in my driveway. And it's, I mean, my driveway's right there. So when I pull on the shoulder, I'm turning in my driveway right away. Or I'm turning in there to back up to my mail.
Do you ever go onto the motel property?
No, sir. Absolutely not. No, sir.
I would ask that these 2 collectively be admitted as.
Can I see those photos, please?
Yes. That's what you judge.
Yours are actually numbers.
Oh, okay.
So, but I've got them.
Okay, thank you. I'm sorry.
I'll take those as 3 and 4 as pictures of the general area there.
Do you ever stop at Mr. Kowalski's place of business in his property and blast your music?
No, I run my music loud in my truck all the time. I go to school every day to pick up my son from school, the younger one, and in Joburg. And you can ask the people that work there, the principals and all that. When I pull in there, my radio is blaring and I leave it blaring.
Do you ever stop at Mr. Kowalski's place of business in his parking lot blasting your music?
Absolutely not.
Okay. Do you ever flip Mr. Kowalski off while you're driving?
No, I've never flipped him off. And my kids are in the truck all the time with me. They would attest to that too. I mean, I'm not like that. I don't flip people off.
And Mr. Gugowski testified, he's called the police numerous times. Have the police ever come and talk to you about these incidents from May or August?
No, sir. I've never had a police officer come up and talk to me and ask me questions about the restraining order itself, about not following the order or doing something wrong with the order. Never had an officer come to my house.
Did an officer talk to you today when Mr. Gugowski states that you were laughing at him?
No,
Okay. Do you ever stop and intimidate Mr. Gugowski?
absolutely not. No, sir.
Has Mr. Gugowski seen you at a store and ever felt intimidated?
Yes, sir. My kids were with me. My youngest one, we were in the little store. It's on the corner there. We were in the store. My truck was always parked by the door. I always parked by the door. That impedes the gas pumps, but I always park right by the door so I can get out and go right inside. And I was in the store at the ATM getting money out of the ATM to pay my rent. Him and his wife come in and he's laughing and talking and living it up. And I thought, wait a minute, now he's got a restraining order on me. What the hell? So I just said to Scott, come on, we gotta go. And I just walked away from the ATM, went right straight out and got my truck. And I drove the truck around into the other side of the parking lot and sat there and waited for Bill and his wife to leave the store. Well, after they left the store, I pulled back in there and went ahead and did my business. And the teller said she would testify to it if I needed it.
I have nothing further, Judge.
All right, Mr. Gurgowski, this is your opportunity if you want to ask the questions of Mr. Gahn.
Mr. Gahn, you say that I threw nails out. Did you call the police to report that?
I did.
And did the police say that there was a violation that I did anything wrong?
Yes,
Or that I threw nails out?
I'll object as to hearsay. I don't think Mr. Gahn can testify as to what the police said.
He didn't ask what the police said, he just asked if the police had ever made any statement, so I'll allow that question.
The police did come to my house asking me about that. They asked me what happened. I told them my son had come up, told me that he saw you throwing nails out there. And that was it. I just told him the story and then said, I'm gonna go down with a magnet, pick them back up, because I mean, we all use that. That's the shoulder of the road.
And did the officer come out, tell you, or was there an arrest made because there was a violation that somebody threw nails in a public right of way?
I have no idea, sir. The officer came to my house, asked me why I called. I explained to him, told him the story. He left, and I never saw him.
So to your knowledge, there was nobody that ever threw nails in a public right of way that you claim?
No. I have an eyewitness that saw you throwing the nails on the driveway.
Were those nails thrown from your eyewitness on private property or public property?
No. No.
Private property or public property is the question, sir.
Judge, I'm gonna.
I don't really understand what he's asking.
It's a pretty
He asked me if
simple,
I threw nails.
it's a
No.
pretty simple question where the nails that you saw on public property or private property, is that your question?
Yes, Your Honor.
No, sir, that is county right of way property.
But you're saying that you have no knowledge that the county police took any action, even though you claim it was on public property?
Yes, sir. He said that he would take care of it and he would talk to you about it, and that was it. I haven't heard from him since.
So without hearing anything from them, would a reasonable person believe that there was no crime committed?
I have no clue, sir. I'm not the law. I don't know.
Again, I don't think we're here for a criminal charge of whether Mr. Gatt or whether Mr. Gugowski was charged with a crime.
Well, the fact is, I don't have any police reports showing that anything happened, so from where I'm sitting, there's no evidence other than Mr. Gahn's statements.
Mr. Gahn, is there any reason that you would need to enter onto private or public property 30 feet before the road that enters your driveway area? So it's a road. Is there any reason that you would have to exit the public highway onto private property to turn up a road to go to your driveway?
No, sir, not on private property. As I turn out on 612 from the driveway to go toward town, which would be to the left, which is where your place is at. As I turn, I come out on the shoulder because I can't see what's coming up on that corner. And I use my mirror to see if there's anybody coming. If I don't see anybody, then I pull right out on the road and go.
Okay, but on August 1st, you were coming from the opposite direction.
Okay, yep.
So you would have had clear sight to turn onto your property. So is there any reason you would have to exit the road to turn up
On that shoulder?
the road onto your property to go to your driveway?
Yes,
Which
sir.
your driveway, the road is 75 feet up to your driveway. Is there any reason you have to exit County 612 Road onto a shoulder to turn 20 to 30 feet prior to your road to get to your house?
Yes, sir. When traffic's behind you, it's a courtesy thing where people just pull off to the shoulder, let the guy behind you go because you're getting off the road. So I use that shoulder just like everybody else does.
And on August 1st, was there somebody behind you that required you to exit the road instead of putting on your blinker and turning up into another road where people behind you would respectfully stop, because that's the law, to stop for somebody turning right? Was there a reason that you needed to exit the road, or was there a car behind you that forced you off the road before 30 feet before you turned up your road?
I've never been forced off the road, sir.
That's not the question.
I voluntarily pull off the road.
Okay, so do you voluntarily pull off the road when somebody's standing there?
I have an eyewitness.
Do you voluntarily pull off the road when somebody's standing there?
Not in the middle of where I'm driving, no.
Okay, so can you explain to the court why you voluntarily pulled off the road that day to come within inches of somebody who you have a court order to stay away from and not be around and come that close to that day?
Yes, sir. When I look in my mirrors, I see a car behind me on the corner behind me, which is coming from Grayling area, coming into Love's. My son, the youngest one, sitting next to me on that day where you took the pictures. And as I pulled off to the shoulder, he said, "Dad, there's Bill." I said, "Oh, I don't care, because I don't pay you no, never mind." And as I pull off on the shoulder, as I'm pulling off to the shoulder, my son said, "Dad, he's running up to the truck." And I glanced over and you were doing a double time step to hurry to get up by my truck with your little sprayer. And I continued to drive where I was at because I knew that I would not hit you, sir. And I continued and went right up to my mailbox.
Again, sir, was there any reason? Was there any reason?
Give them the opportunity to answer the question.
I think he answered the question. You're just asking it in a different way. I've got the answer. We can move on to your next question.
So on August 1st, did you come within less than a foot of myself on my property 30 feet before you needed to turn up your road as the pictures depict?
Pictures show where you ran up to my truck. I'd like to see the video where it shows that you ran up to my truck.
Your Honor, photos still photos don't lie.
Okay, thank you. Do you have any other questions?
We will rest on our evidence.
All right, thank you.
And also, we would also like to put in the video evidence, which shows on multiple occasions Mr. Gahn entering the road at his road when I'm not present. We'd also have the video show that he stops on my property when I'm there, and with his blasting music coming as close as he can when I'm present. And these things only happen when I am there, my car's there, my family's vehicles are there, and he sees them and we're present.
I'd like to be on.
And another question that I do have is, Mr. Gunn, are you in possession of a firearm?
And I'm gonna object as to the relevance.
Well, right now, or
Sorry.
Your Honor, so the order that you signed says that Mr. Gunn is not to be in possession of a firearm. Mr. Gunn's, according to the court, and according to what he has yelled at me on the property is, after the last court hearing, I got my guns back. So not only is he in violation of every aspect of the personal protection order, he is also in possession, currently in possession of a firearm, which is against the order that this court has signed.
I understand what you're saying. I don't know that him yelling that at you, if that's true, is enough to prove that he actually has firearms in violation of that order.
But if the sheriff's office, after the last hearing, returned his firearms to him, and he just admitted that he's in possession of a firearm, that is in 100% violation of the protection order that was signed by this court.
Mr. Dunn, just stop for a minute.
Okay,
There's no question.
So, I mean, the order does say he's not supposed to be in possession of a firearm. So, Mr. Khan, if you have any firearms, you're not supposed to be in possession.
Okay, well, I'll get rid of them then. I did not know that. When the other court case was over.
I don't want to hear any explanations.
Okay, all right.
You're not supposed to be in possession of any firearms.
I apologize. I'll get rid of
Mr.
them.
Dunn, shut up.
Mr. Gerber, did you have any more questions?
I'm sorry, Judge.
That's all right, I understand.
I have no further questions.
All right, Mr. Khan, you can step down. Mr. Gerber, any further questions?
No.
All right. Okay, I've had a chance to review the exhibits that were submitted by the parties. I've had a chance to hear the testimony of both the individuals here today. The allegation is that there've been a number of different violations of the order. I'm looking specifically at Mr. Gergaski's exhibits A1 through A4 that he testified to, and I understand Mr. Gergaski's offered additional evidence on video. This is a hearing as to whether or not Mr. Gahn violated the personal protection order in this case. The court has to allow both sides to present evidence and testimony. As the court has to find if it's going to oppose a criminal sanction that Mr. Gahn violated the personal protection order beyond a reasonable doubt. For a civil sanction, the court has to find that he violated the personal protection order by clear convincing evidence based on the court rules. Applying those standards and looking at the evidence here, what I find to be most compelling are the pictures that Mr. Gergaski submitted. And what I find compelling about them, because they do allow a very specific vantage point here. And when you look at where Mr. Gergaski is in relation to, and I'm stating this for the record, but there's a post right here that's right by where Mr. Gergaski is. And when you look at all of these photos, his position in relation to that post is exactly the same, which tells me that Mr. Gergaski is not moving towards this truck. He is staying in the exact same position in all three of these photos in relation to that post. It's clear to me, based on the location of Mr. Gahn's truck, and you can see Mr. Gergaski's shadow on the truck. He is very close to Mr. Gergaski during this drive-by. Mr. Gahn, I don't believe that you were pulling into your driveway and that's why you were that close to him. I don't care whether your tires are on public property or private property, because the personal protection order prohibits you from confronting or approaching.
Yes, sir. I understand. He ran, or double that ran up to the truck. I've got a
It's my
witness.
turn to talk right now, okay?
Okay, I'm sorry.
Whether it's on private or public property, under the personal protection order, you're not supposed to confront or approach Mr. Kurgatsky. And in my view, I think under a common sense view, you're clearly driving as close to him as you can in that picture. Whether you're giving him the finger or not, you can't see that in the picture. But to me, that's really not that relevant because you're driving right up to him. And you're getting within inches of him. And in my view, that's a clear violation of the personal protection order. And that's to say nothing of the fact that you have a copy of this order, which says in pretty plain terms that you're not supposed to possess or purchase any firearms in your possession. You have firearms in your possession by your own admission today. So there's at least 2 violations of this personal protection order as we sit here right now. I also tend to believe Mr. Kurgatsky when he says that you're engaging in kind of a pattern here of intimidating. And I just find his testimony on that point to be credible. And I don't find that, your explanations and excuses for why you're driving the way you are to be credible. I just don't believe you. I think you're trying to do whatever you can to intimidate and threaten Mr. Kurgatsky. And it needs to stop, and it's going to stop.
Yes, sir.
Because this is a first violation of this personal protection order, the court is not going to impose any jail time and going to impose a fine of $500. You already owe a lot of fines and costs on the criminal case, which to date you've only paid $35. We have a hearing coming up on February 20th with regard to payment of those fines and costs. Court, as part of this case, is going to impose a $500 fine.
Okay.
And I'm going to set this for on February 20th as well. You need to start making some payments towards those things. And if you don't, then, and the court finds that you have an ability to make payments, then you are going to spend some time in jail.
No, sir, I don't have the ability to make a lot of money payments. I don't.
Then you're going to have to bring proof of why you can't pay it.
I can write it down right now and show you.
The other thing I'm going to tell you, because if the fines don't work, and if you say you don't have money to pay it, and if there is actual evidence that you don't have money to pay it, then the only other option I have to impress upon you that you can't engage in this behavior is going to be jail time. So if we're back again, and you're found guilty of violating this personal protection order again, that's what's going to happen. You're going to spend some time in jail. So from now on, you need to make a choice about what's more important to you, being out and not being in jail, or messing around with Mr. Kurgatsky. All right, that's the clear choice, because I'm done with this and not putting up with it anymore.
I understand.
You didn't get any jail time as part of the criminal case. I'm limiting it to a fine in this case, even though it's a fairly significant fine. Then I'm done. I'm done with it. If you're found guilty again, it's jail time. That's it.
Right.
So there's no reason for you to engage in this kind of actions towards Mr. Kurgatsky at all. And any leeway that you've had is not done. So the court will sign an order imposing that fine when you leave court today to stop at the clerk's office to make arrangements. To begin making payments on that. Mr. Kurgatsky, do you have any questions about how we're going to go forward?
No, Your Honor, the only question I have is if I need to be here for the February 20th hearing.
No, that's totally up to you if you want to be here.
No, and the only reason I say that is obviously we had to hire someone to take care of my father and make a 1,900-mile journey through 2 blizzards to be here for this. So if I could just submit something, a statement to the court at that time, if need be, and not be here, it would just be a lot easier on myself and my family.
Yeah, there's no obligation for you to be here.
Thank you, Your Honor.
Mr. Kermit, I'm going to ask that you and your client just remain there at the table. Let Mr. Kurgatsky get his parties leave the courtroom.
Thank you, sir.